All right. Well, by my clock, it's 11:30. So for those of us that got here on time, we'll go ahead and start and be respectful of your time. My name is John Miller, and I want to welcome everybody to today's presentation. Have the great pleasure of introducing one of my friends who we also get to share a professional relationship serving others. So it's always fun to know somebody for as many years as Brad and I have known each other, and then to see each other excel professionally. So I'll get to his introduction here in just a second. Um, so we are recording this session. Hopefully you got that notice when you logged in. So just want to be mindful of everyone. If you are asking questions and all that kind of stuff, this session will be recorded. So if you have some questions that you want to ask, offline or whatever, Brad will have his contact information up at the end and do if you're uncomfortable sharing with the group. But, sometimes the best learning, in my experience, comes through, active questions as we're going on. So let's go ahead and address how we're going to deal with that. Katie, my colleague, is going to be monitoring the chat. And if you have a question as we're going through, she may break in and stop Brad and say, hey, so-and-so has a question. Hopefully everybody's muted themselves to start with, because we are all live on this thing. So if you haven't, please mute yourself. But if you do have a question, we want to be able to answer those real time. And Brad is flexible enough to, stop midstream if there's something that's on your mind. And or if you want to ask a question through the chat, Katie will we'll do it that way. We are going to have a number of people on here, so probably that's the preferred method. But if you have a question midstream, Brad said he's happy to deal with it midstream as well. So I think that's all the housekeeping that I have. I do want to introduce Brad Adler. Brad is a native Atlantan. He's an undergraduate from Georgia Tech and went on to Tulane Law School, where he graduated cum laude. He's represented employers in 28 different states around the union, and he represents clients in front of the EEOC, related federal state agencies, including the Department of Labor, in both federal and state courts. And for those of you here in Georgia, he actually serves all of us business owners, and that he's been appointed by the EEOC to the EEOC Stakeholders Task Force for the state of Georgia. And so he represents the business community in that, and is the voice for all of us employers in the state of Georgia. Brad also serves on his firm's executive committee. I was thinking about how to introduce Brad, and my father had a great saying. One of the highest compliments he would give someone is to introduce them as a great American. And I can honestly say that Brad Adler is a great American. And with that, I will turn it over to Mr. Adler.
Well, thanks so much. I appreciate it, John. And initially, I just want to say thanks to you and Sterling Seacrest. What great partners. And I know you serve your clients and have been serving your clients really well for a long time. So it's an honor for me to also to be partners with such a great organization. So January 28th, 1986. For those that were around during that time, you will remember that day because it was with great anticipation that the Space Shuttle Challenger launch would take place. And one of the reasons there was such great anticipation behind that launch is because it was going to be the first mission for the Space Shuttle where a private citizen, Krista McAuliffe, a school teacher, attended or got to participate in the launch. And for those that know the story, 73 seconds into the mission, the Space Shuttle Challenger exploded, to the shock and the horror of the entire nation, including myself. And I still remember today where I was when that occurred. I'm sure those playing on the call that also remember where they were when this occurred. While it was a huge shock to our nation and so many people that were watching, it was actually not a huge shock to several members of the team that were involved in the planning and preparation of the shuttle mission. There were several folks who had raised concerns about whether NASA had done the appropriate amount of risk analysis and whether it was prepared for some of the concerns that morning, in particular, whether the O-rings would stand up to the cold weather that morning. And as it turns out, their concerns materialized into a horrific explosion. My mission today is not nearly as complicated. My mission today is pretty darn simple, and that is to make sure that everybody on this phone call today, on this Teams meeting today, has done their part in preparing for an employee disaster, in preparing for how to manage an employee, for conducting a risk analysis and making sure that you have the appropriate protocols and policies in place that will either mitigate the risk of an employee dispute or potentially avoid an employee dispute. Now, everybody on this call is probably wondering, well, you know, I haven't had one or I had one before, but I'm not going to have one again. So I always like to provide an explanation of the risk and the impact of the risk of not preparing. So first, are you at risk of an employee disaster? And I think the first statistic is a pretty telling statistic, and it should tell everybody on this webinar today that you are at risk for an employee dispute, regardless of where you're located and regardless of the size of your business, because approximately 50% of all businesses have experienced some sort of employment dispute in the last 5 years. That tells me that on average, 50% of the people that are on this phone call today have experienced some sort of employment dispute. And if they haven't already, that just increases the probability that you will over the next 5 years. And when we talk about the risk of an employment dispute, we really are talking about two buckets of impact. So oftentimes we hear what I will call the first bucket, which is the hard cost. And that is pretty easy to figure out and quantify. Is how much does it cost you when an employee brings claims against you and alleges you've done something wrong? And as you can see by the presentation here, the average cost to defend yourself in an employment dispute is about $160,000. Now that's a lawsuit. The average lawsuit settlement for harassment claims just in and of themselves is between $75,000 and $125,000. And if an employment lawsuit actually gets to a jury, employers lose about 65 to 75% of the time, and the average judgment is between $1 million and $2 million. Those are, the quantifiable cost, the hard costs associated with experiencing an employment dispute. But I would tell you, for those that have dealt with particularly a long-ranging employment dispute, they will often tell you that it is the soft costs that are actually more painful than the hard costs. The soft cost being the time that is sucked up by dealing with an employment dispute and the mental energy that is associated with it, having to talk to me all the time, having to respond to discovery, having to be subjected to depositions, to having to attend depositions, all things that produce literally zero revenue for your company. And while I have 2 boys in college, I'm happy to get paid. I don't produce an ounce, a penny of revenue for you all. So today, we are really going to focus on 5 ways that we can mitigate or reduce or avoid the likelihood that you have to experience these 2 buckets of impact, hard cost and soft cost. For those that don't know, our firm is based here in Atlanta. I like to say it's born and raised in Atlanta like myself. We now have over 30 offices and over 450 lawyers across the nation. I do tell folks I was the 17th lawyer here about 26 years ago. So it's been a fun and interesting run. Since I'm going to be talking to you for about another hour and 20 minutes, I figure you may want to know a little bit about me aside from what John relayed. So I'm born and raised in Atlanta. I went to Georgia Tech and then went to Tulane, as John mentioned. I have two older brothers, Scott and Todd. I love watching Georgia Tech football, some years more than others. My favorite band of all time is U2. And I am married to Holly and with our two boys, Carson and Cameron. So let's dive right into this. What's the first step here? What's the first thing that we can do as employers that will mitigate, reduce, avoid the likelihood of an employment dispute? And this first part, you'll see what the title is, protecting yourself against the underperforming employee. I tell folks all the time, I don't have a job. I'm not as busy as I am now or have been since 1998 because of good employees. The reason that I have a very busy practice is because there are lots of underperforming employees. And what's interesting about underperforming employees is so often the time that when you talk with your employees who are not meeting expectations and you ask them about their opinion, they will disagree as to whether they are performing up to expectations. It is rare when you call them in some sort of counseling meeting, will raise their hand and they will say, you know what, you're right. I'm not doing a really good job. You're right. I'm not really engaged. You're right. Actually, I'm coming in late. And even when I come in late, I take a long break and then I come back in and I eat lunch and I take another long break. For those that like the movie Office Space, you'll know what I'm talking about. And so what's interesting about that concept is that there is one image. There's one image that we're looking at, which is performance. But we have two very different perspectives on what that image shows. I would like you can raise your hand. How many people see the young woman in the picture that is displayed on my screen? By just raising your hand. I'm going to give it about 5 more seconds. Be proud. Come on, folks. Who sees the young woman? Okay, we got a lot. Now, who sees the older lady in this image? Not nearly as many people. And yet there definitely are two images. There's two pictures within this one image. Just like many times when we are counseling folks, there are two opinions on performance. And so we have to keep in mind that when we're counseling people that are underperforming, it is rare that they're going to readily agree with our opinion. So with that being the case, how do we get them on board that they're not performing up to expectations, and 2, create a pathway where if there's a dispute down the road that we can sufficiently defend ourselves and articulate why we did what we did. And for that, folks, I'm going to jump into a couple of slides. So this is a really interesting slide, and it shows, it's from a few years ago, and what it shows is that 78% of all employment lawsuits arise out of wrongful termination or alleged wrongful termination. And if you think about it, it makes a lot of sense, because when you terminate an employee, you are, particularly a long-term employee, you're extinguishing two things. And if we were all together, I would ask you to answer this like my dad, who was a college professor, would ask Socratically, but I'll give you guys the answer. 1, we terminate their ability to provide financially for themselves or for their loved ones. And 2, particularly for long-term employees, you may be terminating, extinguishing, eradicating their identity, their ego, because for so many people, that their job is one and the same with who they are. And I'm sure there's people on this call that have experienced or have known folks that have been at a place for 42 years. And so they are one and the same with that organization. So when we terminate somebody, we're terminating potentially their ego, their identity, and we're certainly terminating their ability financially to get money in. And if I told you about those two things were terminated, you would tell me that that is a recipe for someone being really mad. And that's why terminations lead more than anything other, any other adverse action, they lead to employment disputes. Now, what's interesting about terminations is this. Terminations are the very end of the process. It's the last thing that happens in your relationship. And when we hire someone, we actually have no idea whether we're going to be terminating them. We have no idea if they're going to be good or bad. It would be so easy if, when we asked somebody during an interview, hey, tell me about you as an employee. And that person said, well, in about 8 months, I'm probably going to come in late on a regular basis. I suspect that I'll probably leave early a little bit. And even when I'm here, I'm not going to be very engaged. It'd be really easy if someone told us that, because then obviously we wouldn't hire the person. But the problem is they don't tell us that. So we never know until the very end of the process that we're going to terminate somebody. And because it's the end of the process, we can't go back and recreate things that took place over that period of employment. And I'll talk about this in more detail in a little bit, but that's why it is so critical that we are in tune with some of the things I'm going to talk about from the very beginning of the employment relationship, because we never know who's going to be your employee disaster. Now, this is a fascinating slide and really gives a lot of insight. So this was done a few years ago. It was a study. They asked a bunch of people, and the question that was asked is, in a dispute between an employee and an employer, who would you tend to believe? Without knowing anything about the people, without knowing anything about the company that was at issue, 88% said they would tend to believe the employee. What that means is when I walk in a courtroom with you, that most of the time I'm facing the reality that 88% of the people who sit in the jury box are going to, not because of anything that you've done, not because they know you, not because they know the plaintiff, but simply because of this particular seat that you sit in versus the plaintiff, they 88% are going to believe at the outset the employee. So over the next few slides, part of what I'm going to teach you is how we flip this script, how we flip it to where an employee is on the 12% and the employer gets 88% of those folks that are judging us in a dispute with an employee. Now, you'll see I have also highlighted the term employer. This is really critical for those that are listening. So when there's a dispute between an employer and an employee, it's really not a dispute between the employer and the employee. It's really truly a dispute between the employee and his or her manager or supervisor who's taken the action that they're objecting to. So while the name on the pleading oftentimes is the organization, in reality, it's a fight and a dispute between the manager who took the alleged bad action and the employee who was subjected to it. And that's an important distinction, because it's the way that we get our managers to buy into this. You're going to hear me say this many times, that I'm talking to you all, but you're really not the front line. The front line are your managers who are interacting with your employees, managing your employees, making counseling, disciplinary decisions, promotion decisions with your employees every day. Next slide. Managers should be able to explain why they took disciplinary actions. In this same study, 98% of those that were polled concluded that, yes, a manager should be able to explain why they took disciplinary action. And by the way, it makes sense. I don't know how many folks on this webinar have kids, but I'm guessing a fair amount do. And here's what I would propose to you. If I told you that your son or daughter came home from 6th grade and said, I've been suspended from school, the first question that most of us are going to ask is, why? What happened? And then you're probably going to want to talk to the individual at the school who made the decision, who has knowledge of the situation. And if you ask that teacher or that principal or assistant principal why your son or daughter was suspended and they can't explain why, it immediately creates doubt and skepticism on your part. And that is 100% the same principle that applies when you have a judge or a jury that is assessing you and assessing your credibility as both a manager and as an organization. So 98%, folks, believe that you should be able to explain why you took disciplinary actions against an employee. Here's the next interesting slide. In the same study, they posed this question or this statement, and they asked their opinion. The manager is lying if the manager does not properly document an employee's performance problems. 91% who are going to be judging you in a dispute believe that the manager is lying if they said that the employee had performance issues, but there's nothing in writing that reflects it. Final slide before I get to the what I call one of the key silver streaks here is this statement. Employer with documentation that reflects disciplinary action is more believable than an employer without documentation. Guys, look at this. This is just absolutely key. There's no reason not to take this in. 95% of those that were surveyed believe that an employer, you all on this call, your managers that you have worked for you, are more believable simply if they document disciplinary action. 95%. So if you want to know how we flip the script to where we get that 88% when we're being judged by a jury, this is the answer. And I came up with this phrase years ago, and it's called counsel doc. What it really means, you can call it anything you want, but what it really means is that when we counsel employees, we have to make sure that there is a document behind that counseling. And if you think about it, it makes sense because when we talk to our employees about poor performance, we don't simply hand employees a disciplinary action notice and walk away. No, what you do is you talk with them, you counsel them. That's counseling part of it. And then you document the counseling. If you only do the counseling part, folks, you're going to go into back to the 12%. And that's not a very friendly place to be when you're being judged by people that don't know you. So what we now know is this is the number one way, the absolute number one way that you can mitigate, reduce, or even potentially avoid an employment dispute. And I say mitigate and reduce because the reality is there's just only so much you can do. Sometimes you're just going to have an employment dispute. But here's what I'll ask. If we know that we're going to have an employment dispute at some point in the next 5 years, why wouldn't we want to do everything that we could in our power to reduce our exposure and to give us more arrows in our quiver to win?
Brad, let me pause for a second. Linda Martin raised her hand, and I don't know if that was because, Linda, you had a question. If you do, you want to pipe in with unmute and ask your question? Or it might have just been an errant hand raise.
No problem. Linda, if you want to, there we go. Linda, you have a question?
Linda, we can't hear you. I see you're unmuted, but we can't hear you.
Yeah, and so Linda, if you'll just put it in the chat function, that way we'll continue to move. But I'm happy, and Beth, I see that as well. Yep. So you can unmute yourself, you guys, and you can talk, or you can put it in the chat function.
Go ahead, Beth.
It's probably easier for me to talk. Can you hear me?
Yes.
Yes.
Go ahead.
Okay. So I'm pretty good about documenting things, but does the employee have to sign the documentation all the time?
This is a great question. This is a perfect segue into my next couple of slides. I will answer your question, Beth. If I haven't answered your question by 3 slides from now, I want you to come back on and yell at me, okay?
Okay, thanks.
All right. So if we are going to document, let's make sure that we document the right way. If we're going to go to the effort of doing this, let's document it the way it's supposed to be done that gives us the best ability to defend ourselves or to convince somebody else that we didn't do anything wrong, which means that we need to have the date it was prepared, the date we discussed the counseling, the date of the event that is the basis of the counseling, what was the event, and what is the consequence for that person having engaged in that conduct, and what's the consequence if it happens again. And by the way, on the consequence, I'll just tell you unless you're terminating them, easy language to always remember is additional issues of the or additional performance issues may result in disciplinary action up to and including termination. You can put that on every single one. Now, here's what I'll tell you. If you are at the end of your line with somebody, then you need to say on that document, whether it's a final warning, whatever it is any additional tardies, any additional attendance issues will result in termination. I like the idea of making sure you're telling people, hey, this is it. This is your last chance. And you could even do a last chance agreement. But I like putting that in there. Now, this next bullet point, you see where it says signatures by supervisor and employee. So obviously we can control whether the supervisor signs it. That's easy. So the question is, what happens when an employee gives or pushes back against him or her signing it? So first, here's a pretty easy tip. So I don't know Deanna, but I see you, Deanna Shepard, you're on my screen. So if Deanna is the person who I am counseling and Deanna says, I'm not signing this, here's my response. Hey, Deanna, this is going to go in your personnel file, regardless of whether you sign it or not, and I'll have somebody witness it. But if you don't agree with something, or if there's something you want to say, don't you think it would be important that you make that comment on this document? So if anybody pulls this document in the future, then your response will be directly on it. You say it like that, and most people will be like, heck yeah, that's right. I want to put something on there. And I don't care what they put on there, because when they put it on there, I've got their signature. Now, that's a great way. That's the best way. It's the top of the tier is to have the employee's signature. But one other way you can do it is, for most of the folks that are on this call, the employees that you're dealing with have an email address. And they have an organizational email address. And so if someone says, I'm not signing that, it's real easy. You sign it, and then you send that person an email that says, hey, Connie, I know you refused to sign this today during our counseling session, but I wanted to make sure that you had a copy of it. Boom. And then you hit send. Now, here's what I will tell you, and it's this last bullet point. If I can't put my hands on that counsel doc at the time when I need it the most, which is something you'll never be able to predict until it happens, it's as if you didn't do one at all. And remember, from the survey we saw, if you as a manager or as an organization say that you counseled somebody because they weren't doing a good job, and yet you can't produce a counsel doc that supports it, what do people think you're doing? If you don't remember, the answer is lying. When I'm being judged by people and there's money on the line, guess what? The last thing I want people to be judging me as is lying. Okay. So if you're going to go through all these steps and you're going to say, listen, I remember when Brad said counsel doc, and darn it, we're going to counsel doc. And I can't get my hands on that. It's not in the personnel file. It's as if it didn't happen. So in the instance where you're sending the email, all you need to do, if you're the manager, is forward that to HR and say, please put it in Jimmy or Susie's personnel file. If you are the HR person who is issuing the counseling, then obviously you can print it out and put it in, or if you have a digital file, you drop it in. So that's the second way, and I think that's a great way. I love those emails. So if someone says, well, I didn't get it, no, they never talked to me, I produce the email with the attachment. And obviously the final way is what we call a memo to file. A memo to file is, on this day, I spoke with John Miller about John coming into work late the last 3 days in a row, right? And then I print it out and I put it in the personnel file. That's better than nothing, because the idea is how many people are going to, create a document 11 months ago. That isn't true, but it still gives the employee the opportunity to say, well, they never talked with me. I didn't have a meeting. So it's the lowest tier, but it's better than nothing.
So Brad,
did that answer your question? And John,
Yes,
yeah, it sounds
yes,
like,
thank
okay.
you.
Yeah, so
Of
Brad,
course.
we had a question come in from Tony Kim, asked, does the employee have to agree with the documentation?
No, not a bit. Absolutely not. In fact, guys, we know from that picture I showed you before that most people are going to say, I am doing a good job. And it is, how many times have you heard about car wrecks where one person says, nope, I had the green light, and the other person says, nope, I had the green light. Well, in this world that we deal with, the issue or the focus is on what we believe. What is our good faith belief? So even if the employee disagrees, that's just not our concern. Now, that's not our concern from a legal perspective. Obviously, part of what we're trying to do through Counsel Doc is performance pivoting. We're trying to get people to pivot from whatever direction they're going down to a better direction. And I think, frankly, Counsel Doc, in addition to protecting companies, also can do a better job of triggering change. But no, they don't have to agree with it. And frankly, most of the time they don't. So again, if we're going to document, we got to document the right way, or it doesn't make sense to document at all. And so we want to be consistent in our documentation. Now, that doesn't mean we treat every situation the same. There are some situations that don't require the same type of discipline, whether it's because the person has only been there 3 months versus 16 years, or the type of behavior or conduct that we are counsel docking is different. I do not like the term verbal counseling, because most of the time it's the managers that are giving the disciplinary action. And if I put in there, hey, please give that person a verbal counseling, and that manager has not been through this training, then what does the manager think they have to do? That all they have to do is do what this says, which is, I have to talk with you. But going back to the Counsel Doc, that's only one part of the 2 parts. And you got to have both parts to make this an effective approach. So please do not use the term verbal counseling. I even like, as an example, 1st level written counseling, 2nd level written counseling. If you want a 3rd level, that's fine. But I like the idea of making sure that every single time the word written is in there, or Counsel Doc. We sometimes see that supervisors will hold off on addressing an issue, particularly for newer individuals. All right, let's just see if it gets better. Oh, well, that's actually just Susie being Susie or Johnny being Johnny. And now, a year and a half later, it's come to a head. The manager comes to you all as the practice administrator, as the CEO, or as the HR director, and says, I want to get rid of Johnny. Darn it, I want to get rid of Johnny yesterday. But at the latest tomorrow. And then you call me and you say, hey, Brad, we have somebody who wants to get rid of Johnny. And I say, send over the personnel file. And I open that personnel file. The person's been here for a year and a half, and I don't see any counsel docs, or I see one. And I ask, well, what's the problem? You say, well, for the last 8 months, they've been really bad in this area. What does that look like? It goes back to that slide that if there's a performance issue, people say that they want to see some consistent counsel docking. They think that's the fair thing to do. I did see there was a chat of a question. Let me just see if I can get that real quick. So would you say first warning instead of verbal warning? Absolutely. And look, if your managers knew that verbal warning meant that you also have to document it, then I wouldn't really care. But again, I don't have a job because managers are doing an incredible job of counsel docking. Right? I have a job and I'm busy all the time because people are not either counseling people at all, or if they are counseling people verbally, they're not documenting it or memorializing it in writing. But again, if you call it a verbal warning and there's a document behind it, perfectly fine with it. But part of what I'm sure you guys have heard KISS, keep it simple, stupid. And I like to apply that because I know that lots of people have lots of stuff going on and managers have a lot of responsibilities. So I just want to make it easy for them and not have them wonder, particularly if you have new managers that come in that may not have gone through a training about what verbal warning means.
Brad, we had Darcy raised a hand. Darcy, I don't know if you had a question. All right, we'll keep going there, Brad.
Yeah, and Darcy, if you unmute yourself, just ask away. Probationary period, we hear this a fair amount. Well, can I fire them? They're in the probationary period. No, the probationary period is really a useless legal period. It has no impact. You can't do something within the probationary period that you can't do outside of the probationary period at all. The other thing that we hear sometimes is, well, isn't Georgia an at-will state? Sure is. So if you want to fire somebody for having blue shoes on or a green shirt, you can, but you can't fire somebody for an unlawful reason. And the at-will principle and the at-will doctrine doesn't insulate you from that at all. And then finally, the privacy of the disciplinary process. I believe in this. We praise in public and we punish in private. Okay. And if you want to irritate an employee, and if you want to make that employee defensive and create some friction, then you will criticize that person in public. So again, praise in public, punish in private. Now, the end of the process, that termination event. Remember, that's the end of the process. So we can't unspill milk that's already been spilled, and we can't create documents that were supposed to have been created 6 months before. So hopefully you've done a good job. And then you get to this termination event. And typically the forms that are filled out is an internal form that reflects what happened. And then if you're in Georgia, it's the DOL 800 form. Here's what I would beg of everybody on this webinar. We want to make sure that the termination reason that is listed internally, whether it's in your software program, your HR software, if it's on a piece of paper, if it's on the DOL 800 form, we want to make sure it is 100% accurate. Oftentimes we see where employers trying to do the right thing and trying to be nice will, for instance, put on the DOL form, lack of work. Can't tell you how many times I've seen the lack of work box checked, and I get the case in, and it's a discrimination case, arising out of a termination. I said, why'd you terminate the person? Because he was doing a terrible job and he was always late. Well, why'd you write lack of work? He was a nice guy and I wanted him to get unemployment. So now you have filled out a document that you know is false, and it's a government document. And now you're articulating a different reason in the midst of a lawsuit that is different. How does that make you look? Does that make you look suspicious? Does that gain you credibility, or does that lose credibility? Of course, it loses credibility, and it loses credibility at a time when we most want credibility, when 12 people are judging us, or a judge is judging us, or an arbitrator. Now, here's the deal, though. Just because I want it to be accurate doesn't mean it has to be a novel. In fact, it can be less than 10 words, probably less than 8 words. I've given you some examples here. Failure to meet expectations. That would cover a universe of bad issues. So I don't have to identify every issue. Attendance punctuality problem. That means I don't have to identify every date that he or she was late or left earlier or missed an entire day. Failure to exercise appropriate judgment. One of my favorites. When someone doesn't do something they're supposed to do, let's say they have a bad interaction with a customer, or another one is like harassment issues. When someone interacts in an inappropriate way with a colleague, I don't put in there sexual harassment, which I'll talk about in a second. Instead, what I say is failure to exercise appropriate judgment in interactions with coworkers, right? So that covers everything. So I don't need it to be detailed, but I need it to be broad enough that it would capture every single thing that was relied upon. One final comment on this. Most terminations, I would probably say 95% of terminations, are because an employee is just not doing a great job. Maybe they're not smart enough. Maybe they don't get it. Maybe they don't want to get it, or maybe they got something going on in their lives and it's causing them to be disengaged or come in late or leave early. But most of the time, it's just they're doing, excuse my language, a crappy job, right? And because of that, there is not one singular event that triggers the termination. Rather, it is a combination of all these things that have built up. But for most terminations, in fact, I would say for all terminations, there is always a triggering event. There is a final straw that breaks the camel's back. Please do not just list the final straw. Please do not just list the triggering event if there's more than one event that contributed towards your decision making. I've seen this too many times where someone comes in late and then they'll write on the termination form, Johnny was late on September 15th. Okay, so you terminated Johnny because he was late one day? No. Johnny had been late 42 times before that, but that's not what you said on your form. But if you say attendance punctuality problems, including coming in late on September 24th, then you captured it all. You've put a phrase that encompasses all of the straws.
So Brad, we've got a couple of questions. First is, will you address during your talk inappropriate behavior like bullying versus job performance issues? And the second one is, do we need to fill out a DOL 800 if an employee gave us a resignation letter?
So here's what I'll tell you. Technically speaking, for anybody who whose employment separates in Georgia, you're supposed to give a DOL 800 form. Realistically, I would say 80% of the clients that I have do not fill one out for a resignation unless it is a problematic employee and you want to make sure it is clear that it's a resignation, then they'll fill one out. Technically, you're supposed to do it, but there's plenty of people who don't. But if it's a problematic employee and there's a question as to whether they terminated or resigned, one, I'd want to put voluntary resignation on the form. And in addition to that, I want something in writing from them, or at least an email to them from us that says, I'm writing to follow up on our conversation earlier today where you gave us your resignation. We accept it, blah, blah, blah. And then what was the other question?
Let me address inappropriate behavior, bullying versus job performance issues.
Yeah, absolutely. But I'll talk about that at the very end when I go through the handbook, the standards of conduct policy. These are great questions, guys. I mean, keep on asking. I love these. And I assure you, if you have one of these questions, then someone else from the audience is going to gain a lot of value by your asking it. So thank you. All right. So if you haven't been listening as well as you should have, although you should, because counsel docs is critically important, but for whatever reason you haven't, I need you to pay attention to this slide, because this slide more than any may gain you more value. It may gain you more money. It may save you more money than any other slide on my PowerPoint. And that is the use of arbitration agreements. And I am a massive fan of arbitration agreements. And an arbitration agreement, for those that don't know, is an agreement between the employer and the employee where both agree that if they have a fight with each other, that they'll fight it out in an arbitration. There are cons to that. There's really no appeal rights. You have to pay for the judge. But here's what I know. I know plaintiffs employment lawyers hate arbitration agreements. You know why? Because there's no jury. And you have a 22-year lawyer who's not going to be swayed emotionally by things, and he or she is going to be guided by what the law says. So I would plead with you all, if you do not have arbitration agreements with every one of your employees, you are creating an exposure point. You are leaving a gap that easily should be filled. And I'm going to show you just in a second. I'm going to give an example of one. So anyways, these bullet points are really big. They just note what the arbitration agreement should say. The one note here is the very last bullet point. Congress passed the Ending Forced Arbitration Act, and you are no longer, as an employer, allowed to compel the arbitration of a sexual harassment or sexual assault dispute. But for those states other than Georgia, if you're in other states, that's where a jury trial waiver would come into hand, and we would just have it before the judge. Now, here is an example of an arbitration agreement. And you can do it two ways. You can have a standalone agreement, okay, that people sign, and that's perfectly fine. But for a lot of my clients, they want kind of the 2-for-1. What do we know that we have to get from everybody as an employee? We know we have to get an acknowledgement of the employee handbook from everybody. And we know we have to get it when they start, and we know we have to get it when we update it. And so this is a way to get a 2-for-1. You'll see the top part of this document is the handbook acknowledgement. And the bottom part is their agreement to arbitrate and their waiver of their jury trial rights. Now, again, in Georgia, you can't actually waive your jury trial rights, which is why we say to the fullest extent permitted by applicable law, because I think it's Hawaii or California, but definitely Georgia, that doesn't allow a jury trial waiver. But this is a super easy way to get the arbitration agreement signed by the employee. And now you've got that in effect going forward. So
I think you're muted. It looks like Brad dropped. Let me see if I can get a hold of him.
Brad should pop right back on here. He must have clicked the wrong button.
Uh-oh.
Wonders of modern technology.
Hey guys, you there?
Yes.
You're here.
Yeah, I don't know. It said someone kicked me out of the meeting, so someone didn't like me. Sorry, I irritated someone by talking about the arbitration agreements, but I still believe them just as passionately, guys.
Yeah, if you could pop your screen back up, Brad.
Yep. Okay. Here we go. So I really believe in this. I think it's the number one way to reduce your exposure and to avoid runaway verdicts. Now, how do you implement these? Easiest way is that the new hire stage, employees will sign anything, so they'll sign this. But obviously for current employees, I think it's easier when you do it as a part of the rollout of a new handbook. But again, if I can't find that acknowledgement, if I can't find that signed document, it didn't happen. You can't say, well, we have everybody do it. You got to produce the actual page that has the signature. I get asked a lot, are electronic signatures okay? 100% fine, as long as you can show through an audit how it is that person that signed it, and whether it's a unique ID or they had to sign into their own password portal, whatever it is. But you can't just have them come in and sign something electronically and there's nothing that from an audit perspective would confirm that they did that.
Brad, before you move to the next section, we had a question from Beth Coxwell. It says, for someone who gives a lot of pushback when asking them to do something, and it happens pretty often, what would you document the reason on the DOL 800 form?
Yeah.
Is it for termination?
So you could, if you want to go really broad, failure to meet expectations, because in my view, when someone refuses to do their job, they're failing to meet my expectation. But if you wanted to be specific, you could say failure to comply with company instructions regarding, documenting project expenses or whatever it is. That's fine if it was singular. But again, if it's just they're pushing back on a whole bunch of things, I would be fine with failure to comply with company expectations or meet company expectations. Now, remember, that's the final termination document. You've got to have the timeline of documents that explains what it is that they didn't comply with or they didn't meet the expectations in.
So Lori Morgan asks, to clarify, in Georgia, the arbitration agreement will not stand, correct?
100% it will stand. The only thing, 100%, I've had 3 arbitration trials in the last 4 years, one last year for a very large company here, and it was they wanted $1 million. And we tried the case for 4 days and we prevailed on it was a race and retaliation case. So 100%, but you just got to make sure your arbitration agreements are enforceable. I see messed up ones all the time because they were not vetted through an employment lawyer who understands about arbitration agreements, what the courts will enforce, but they will absolutely enforce them in Georgia. I get them enforced all the time.
If an employee won't sign one, what do you do, Brad?
So it's no different than if you ask an employee to do anything else. If they do not sign it, then you have to say, signing this is a term and condition of employment. And if you're not willing to sign this document, I can't continue to employ you. I want to employ you. Johnny, I like you, but this is no different than any other expectation we have in terms of a term and condition. And so you got to sign it. And you really have to make it a non-negotiable. Now I'll say this, guys, a lot of times people don't sign them because they have the wrong impression of what they are. And so a lot of times it's the messaging and to say, hey, look, we're not taking away any rights. You can go for the same amount of damages. We will pay the arbitrator's fees. You won't have to pay anything. We get a private judge. It usually takes 2 or 3 years, to go through the process in the federal court system. Here, we get our own private judge. He or she schedules everything with us. So we can get through this process in 6 months. So it actually benefits you and it benefits us. That's, to me, the messaging part. And a lot of times when someone pushes back, if you say, hey, what's your concern? They'll say, well, darn it, I don't, I think I should be able to get whatever damages that I can get in the court of law. Well, we agree with you. And that's why the arbitration agreement doesn't take away any of those rights.
So a couple other questions. If you discontinue a position, what do you write on the form when you part ways?
Elimination of job position. But here's the key. There's always, this is always the key. If you're going to call me and you can say, Brad, we want to eliminate this position, do you have an issue with it? I say, no. I mean, if it's a true job elimination. But here's what you have to understand. If you then hire someone back into that position 3 weeks later, you got a problem. So I tell folks that if you're going to eliminate a job position, you're going to need to probably have 2 months before you can reassess and decide that you truly need that position again. Will you provide an example of the arbitration agreement? It's actually in here. Allison, you can go to this page. Now, I can, if you email me, there's a standalone agreement that's about 4 pages. But frankly, this does what you need to do. And it's frankly easier because they're signing the employee handbook at the same time. So you just take that bottom. Actually, this should be your handbook acknowledgement agreement to arbitrate. Okay, so part 2, guys. And these are amazing questions, so thank you. Part 2 is dotting your I's and crossing your T's and responding to a harassment complaint. Here's what I'll tell you. You have all of the control to decide if you want to do a good job in response to a harassment or discrimination complaint. You have total control to decide what the protocol looks like. Now, sometimes people may not cooperate with you in the process, but you have the ability to control what the structure is. And today we're going to talk about the structure. So I'm not going to go through individual examples, but I'm going to give you some templates. I'm going to give you the structure that you should follow. Not every other time, not every Tuesday, not every Thursday, not when the Braves are playing and they win. It's every time that you have someone who is complaining about harassment or discrimination, you need to follow this protocol if you're trying to shore up exposure points. First, I just wanted to remind everybody that there are a whole lot of ways that harassment can occur. And I've got here, sexual, but it applies equally to other ways that it can occur. Traditionally, 20 years ago, when I started 25 years ago, it was mostly in person. Maybe it was a phone call, but it was in person. It was one-to-one communication. But now what we see is text, email, Snapchats, Instagrams, people sending TikToks, people sending YouTubes that are just not appropriate or even showing it. I even had one yesterday, a harassment complaint from a client that they sent me, and it was all about leering. And this person leering up and down each time this female employee came by. So there's lots of different ways, and we just have to remember that that there are lots of different ways when we receive a complaint, and don't discount it simply because it's a little bit unusual. Okay, I've said this like 5 times, but I'm going to say it again. If you haven't been listening, then here is the super important slide on protecting yourself against harassment complaints. You need to have an employee complaint procedure. Now, if you ever ask me to do a handbook, and I do tons of them, I'm going to tell you that I will literally insert a policy that says employee complaint procedure. That way, if there's ever an issue when an employee says, I don't know what procedure I should use to report this, I can say in the deposition, well, can we turn to page 34 where it says employee complaint procedure? So I literally call it an employee complaint procedure. And this is, to me, a great template for one. Obviously, I've inserted some different information in terms of the address and the name, but I love this format and this structure for a complaint procedure. And you'll see what it says is, hey, if you have an issue, go to this person. Go to this person, which is a title. Don't identify a person because people change, people leave. Identify a title. Now, importantly, you'll see, hey, if you're not contacted promptly about your complaint or you're not satisfied, refile it with that same person. But more importantly, you have to send it to this other person. That is a huge deal for us, because if someone says, I called Susie and Susie didn't do anything when I told Susie about what was happening, I then get to say, okay, well, go to the employee complaint procedure. You agree? You see where it says that if Susie doesn't respond appropriately, that you go to VP of HR? You agree with me? You didn't do that, did you? If the answer is no, that is a huge opportunity for us to get out early on an early dismissal based upon a Supreme Court case. It's called Farragher-Eller, but essentially it says if you have a complaint procedure and an employee doesn't follow it, even if bad stuff happens, because bad stuff does happen in the workplace, even if bad stuff does happen, this procedure will give you a massive arrow in your quiver to defeat a harassment, including a sexual harassment complaint or claim. All right, so here's our protocol, folks. And I'm not going to go through every single one, but or the sub ones. But first, when you get a complaint in, we got to assess what it says. Do you understand who said it? You understand what it's alleging? When did the events occur? Where did they occur? And possibly how did they occur? And maybe even why they occurred. All right. So if you get a complaint in that is sufficiently detailed, so it gives you the who, what, when, where, how, why, the kindergarten stuff, then we want to send a generic acknowledgement letter. I'm going to show you a generic acknowledgement letter in just a minute that you can use. But if the complaint came in verbally, or if the complaint is written, but it's really generalized, like what's an example? Hey, I just want, an email. I just want to report that Johnny is really treating me unfairly and harassing me. Okay, there's no way for me to investigate that without more information. Okay, and when that happens, when a complaint comes in verbally or it's written but it's not sufficiently detailed, we have to send a follow-up email to the complainant requesting documentation. Now, I told you I was going to show you an example of if the complaint itself is detailed enough for us to initiate an investigation. Then we send an acknowledgement letter. That's point number 2. Here it is. Okay, I'm not going to read this, but what this says is, hey, thanks so much. We're in the process of reviewing this. I will read this one statement because I think it's really important. Please understand, however, that reviews like this can sometimes take longer than people want or expect, but I'm sure you can appreciate that we need to review these allegations responsibly. Right? It's just telling the person, I hear you. We recognize you filed your complaint, and we're concerned about you, and we're not ignoring you, and we're going to go through the process. That's it. It's an acknowledgement letter. I love this letter. It should happen every single time when there's a complaint. Now, if the complaint is verbal or is not detailed enough to where we can't investigate, here is your acknowledgement letter with a request for more info. Guys, I'm giving you free stuff. People pay me for this stuff. So I want you to please use it. Okay. This is free stuff. There ain't much free in life anymore. So please use this. It's really good information. These are good templates to use. Now, going back, we're now on we've got to assess and make sure the complaint is sufficient to where we have the information that we can initiate the investigation. Now we're on step number 5. Now, we have to assess whether there is any sort of temporary action that we have to take. Is it so bad that we think like, hey, there's no way we can keep these people working together? Or it may be that we can't even keep the alleged harasser working during the time of the investigation. I'll give you an example. Had this last week, the allegation came in for a client that one person raped another person, right? Now, I can't keep that harasser actively working during our investigation. Now, because it's not fair to me, you credit one person over the other without investigating it. Most of the time, what I'll suggest is put the person on a paid leave of absence. The investigation shouldn't take more than 7 days. I think it's the fair thing to do. If it's a salaried employee, you got to be cognizant of some salary deductions issues if you don't. But I think it's the fair thing to do. But regardless of what it is, you have to assess as an organization whether you believe you need to take temporary action while you investigate. Next step, select a disinterested and qualified investigator. Now, you have to decide if that's going to be an internal investigator or external. 90% of the time, it is internal, right? And most of the time, you can identify someone who knows how to investigate. That's number one. You got to have a qualified investigator. And you have to have someone who doesn't have a conflict of interest. I'll give you an example. I had a case 6 months ago where the complaint was against the HR director, right? And so, of course, the HR director can't investigate himself or herself. So in that situation, we didn't think it was appropriate to even go to anybody else who was a director of operations we thought about. We just thought it made more sense in that circumstance to hire an external investigator. They're expensive. Candidly, you're probably going to spend $7,500 on an external investigator. But most of the time, what I have found is they will save twice that if they do a good job, because it just looks so good for an organization to say, we want to bring in someone from the outside to ensure that we're doing the right thing. But that's something you should talk about with whoever your lawyer is at the time as to whether you bring in an outside investigator. If you're ever interested, I have 3 that I think are amazing. All 3 are women, and they just do an incredible job. In case one's already busy, there's usually 2 others that are good, that are available. So we've selected our investigator. Now we start the investigation. So our first thing we have to do is we have to notify, after we've sent the acknowledgement letter, right? We've already done that. Hey, I hear you complaining, and we're going to investigate. And we're now going to notify the alleged harasser of the allegations in writing. And yes, you have to do that. That's the fair thing to do. How can you investigate if you don't have a response from the person? Now, there are times where you may literally just flip the complaint to the alleged harasser and say, hey, here's an email we received from Susie. Please respond back no later than whatever number of days, addressing all the allegations. There's also times what you may want to do is just paraphrase or pull out certain allegations and ask. So there's no right or wrong, and you have to decide that depending on the actual situation. Now, once you have given notice, the next step is you have to give a written statement from the alleged bad actor that addresses the allegations. We have to have something locked in that reflects what he or she says in response. After that, we want to notify any witnesses that have been identified by any of the folks, and we want to secure their written responses as well. Now, I just did this yesterday where I prepared a questionnaire for a client that they were going to give to witnesses in response to a harassment complaint. So I pre-prepared that. Have you ever seen Johnny do this? Have you ever experienced Johnny do that? Have you ever heard any other employees complain that Johnny did this? Do you have any other complaints about how Johnny manages his department? If so, what are they? So sometimes we can pre-prepare that. Clients like that. But you just have to decide depending on what the specifics are of the harassment complaint. All right, so that was number 10. We're on number 11 now. Now we have to secure any evidence that are related to the allegations. What that typically means is it's witness statements, but nowadays it can also mean videos, text messages, not emails as much, but Snapchats, pictures, all those things. You'd be amazed how much is out there when there is this stuff floating out in the world. We get all that evidence, we review it, and then finally, after we've reviewed it, folks, you reach a conclusion. And I have to tell you, this is probably the part where employers mess up the most. So my example is they are the They're the Seattle Seahawks of, I can't even remember what year, when they drove 99 yards down the field in the Super Bowl. They were on the 1 yard line. They had the best running back in the world, Marshawn Lynch, who they called the Beast. And instead of letting Marshawn Lynch run the ball for a touchdown and score the game-winning Super Bowl touchdown, they throw the ball and the Patriots intercept it and win. So they traveled 99 yards and they screwed up at the end. So you can do all these steps 1 through 12, but if you don't reach a conclusion, and if you don't then issue a conclusion letter, it's as if you didn't score a touchdown, you didn't do anything at all. Now, I'm going to give you some examples of conclusion letters, but I want everybody to understand that you may not be able to conclude that it happened. You may not be able to conclude it didn't happen. And in those situations, I've given you some examples here. No evidence to substantiate, or there can be insufficient evidence to substantiate or corroborate. There also can be times where there's insufficient evidence to substantiate that the person did whatever was accused because of the other individual's race or gender or religion. But what they did was still just inappropriate and not up to expectations of your organization. And I'm going to show you an example in a second. But you got to reach a conclusion. What's the conclusion that we've reached about the complaint? And again, here's some factors that you would consider in reaching your conclusion. And every complaint's going to be different because there's going to be different people. And there's different histories associated with those individuals, whether it be the complainant or the alleged bad actor. You've now reached your conclusion, and now you need to make a decision on the next step. Or if you conclude, for instance, that the alleged bad actor did something that he or she shouldn't have done, what are you going to do? And you can give disciplinary action, you can terminate, you can suspend, do nothing, you can make them re-review the EEO policy. You can also have them go through management training, harassment training, sensitivity training. I'll tell you guys one website that I like a lot. There's actually two, is Easy Llama, EASY Llama, as in the llama. EasyLlama.com has really terrific videos, and they're extremely reasonable in my opinion. And the other is Know Before. And Know Before, and the 4 is the number 4. It's actually more of a cybersecurity. It started out as a cybersecurity website to help with cybersecurity training, but they've got some amazing harassment training videos. So those are two good ones. All right, you've reached your conclusion. You've made the decision on what you're going to do. Now you have to relay the conclusion through a conclusion letter to both the complainant and the alleged harasser. And you'll see here I've highlighted, please stay away from using legal terms in conclusion letters. I got a case yesterday where there was a conclusion letter, but here's what they said. We've concluded there's sufficient evidence that you engaged in sexual harassment towards Susie. Okay, great. Then how am I going to claim later on that the allegations aren't sufficiently severe and pervasive enough to rise to the level of sexual harassment when you just said that Johnny committed sexual harassment? So please stay away from using legal terms like, hey, that person engaged in race discrimination, or that person engaged in religious discrimination. Those are legal conclusions. Rather, what I would advise is you could say we've concluded that you failed to exercise appropriate judgment in your interactions with Johnny or Susie or whatever it is. I'm not going to go through these, but because you can look at these later. But these are examples of conclusion letters, different types. You can see the language that we have used. I have changed the names to protect the innocent, or the names and the identities of the innocent and the guilty. But please feel free to look at these as examples as you are preparing a conclusion letter. You'll see here as an example, this is one, the second, where after assessing the information we received during our review, we've concluded that there is insufficient evidence. Now, we didn't say there's no evidence because, the complainant said it happened. So that's some evidence, but there was insufficient evidence to corroborate Mr. Jones's allegations that you acted with any unlawful or improper motive, including based on race, in your interactions. Our review has led us to conclude that, here's why we concluded it. Now, see this next part? while we've concluded that there's insufficient evidence, blah, 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 hey, this complaint is a good reminder that you've got to be cognizant of how other employees may perceive your actions and keep in mind the importance of good communication as we handle various issues. All right, that's great language. So if they ever say down the line, you didn't do anything to John, we get to produce this letter and it looks really good. Here's another one. In this situation, this is a conclusion letter concluding that Mr. Raji failed to exercise the level of professional judgment we expect in his interactions. Now, this was a harassment complaint, but I didn't say that, right? Because I don't want to say that. And this is a letter the conclusion letter that we sent to Roger, where we said, hey, you failed to exercise the level of professional judgment in your interactions with Miss Rand when you put your arms over her shoulders. So those are examples right there. Any questions? Let's see if I see any questions about that before we move on to part 3. No questions. Okay, so part 3, folks. Remember, we're on a 5-part journey here to make sure that we are closing any exposure points we have on employment disputes or employment claims. Navigating employee medical issues, super tough. I think the most complex thing that employers have to deal with on a day-to-day basis with employees are situations where medical issues are involved. And it really is the tangled web. Here's what I'll tell you. I'm going to give you an easy cheat sheet at the end of this. But one of the things you have to do, depending on your size, is you do have to assess, does the employee qualify for FMLA? Then you have to assess, okay, well, whether they do or they don't, do they also qualify for ADA? Whether they do or they don't, then you have to assess now, does the employee qualify for the Pregnant Workers Fairness Act? And frankly, on top of that, you may have the employee sitting out there with a potential work comp issue if they got hurt at work. So you could have an employee who got hurt at work, qualifies for FMLA, qualifies for ADA. Now, if they got hurt at work, it wouldn't be a PWFA issue, but you could have the other 3 implicated all by one workplace injury. I'm not going to spend a lot of time on this because this is like a whole webinar by itself, but for those that are covered, the FMLA applies to entities that are quote unquote covered employers, but the individual also has to be an eligible employee. Now, the covered employer is somebody who has 50 or more employees for 20 or more calendar weeks in this current year or the preceding year. What the FMLA does is it provides 12 weeks of unpaid leave for certain circumstances. And I have listed the FMLA leave circumstances. The biggest key on FMLA is to make sure that your managers are aware of this cheat sheet that I'm going to give you in a second, because I don't want your managers who are making frontline decisions to know what a serious health condition is. I want them to get to the HR person who understands the FMLA. The eligible employee, as I mentioned, you have to have a covered employer, but you also have to have an eligible employee. And this is a description of the requirements to become an eligible employee under the FMLA. Now, there are 3 types of leave under the FMLA. There's block. Block's easy to understand, folks. Hey, I'm leaving, I'm going out on January 1st. I'll be back on March 1st. It's the easiest type of leave to deal with because it's predictable. You can plan for it. You can plan for when they leave and you can plan for when they come back. Reduced schedule is the next type, and that is instead of working full-time, I can only work part-time. Again, easier because it's predictable. You know, they can't work 40 hours. They can only work 20. The last type of leave is the most difficult, and that is intermittent leave. And there's actually 2 types of intermittent leave. Predictable intermittent leave, which is easier to deal with. That is, hey, for the next 4 weeks, every Wednesday, I've got to get physical therapy from 10 to 12. Okay, kind of a pain in the butt because it's the middle of the day, but you can plan for it. The most difficult part of the FMLA to deal with are employees who have unpredictable intermittent leave. Someone has, as an example, depression or anxiety. I mean, I deal with this all the time. And the person wakes up, last Thursday, and there were no issues before Thursday, wakes up last Thursday and they were having an anxiety attack. So they call at 9 o'clock and say, I can't come in today. But meanwhile, a customer was coming in and expecting to meet with that employee at 9:30. And now you're just stuck. And that's why oftentimes managers can get really, really impatient with FMLA situations, is because particularly in the unpredictable intermittent leave, it creates the most headache and heartache for managers managing that type of individual. Remember that we can always require our employees to follow the call out procedure. So even if their absence is covered by the FMLA, if they didn't follow the call out procedure, you can counsel dock them for failing to call or failing to follow the call out procedure. You just can't counsel dock them for the actual protected absence. Employees have a responsibility to notify us 30 days if it's foreseeable, unforeseeable as soon as they can tell us. Meanwhile, we also, as an employer, have obligations to notify the employee of certain rights and responsibilities. Where employers get into the most trouble, folks, is they wait for the employee to use the term FMLA, but most employees don't actually do that. Most employees don't come into the HR office, knock on the door and say, I hereby invoking my FMLA rights. That's not the way it happens. How does it happen? I'll tell you how it happens. Employee comes in on a Monday and says, hey, I think I tore my a ligament in my ankle this weekend playing softball, and I'm got to go to the doctor this Friday, and it looks like I'm probably going to be in surgery the following Tuesday. That's how it happens. Doesn't say anything about FMLA, but does that put you on notice of a potential FMLA condition sufficient to where you initiate the FMLA protocol? 100%. I see a question, so I want to get to what if an employee states that their supervisor gives them anxiety or increases their anxiety? This is a great question. This is something that we deal with, actually. And actually, the other day I had it where the employee claimed that being given a PIP was creating anxiety. So I'm like, that's a tough one. But here's the reality. The reality is that if you have a situation where an employee claims that the supervisor is giving them anxiety, to me, I view that as a harassment complaint or some sort of complaint that would then initiate our complaint protocol. And so at the end of that process, we're going to determine whether there is sufficient evidence that they did that or not. But let's just say that we conclude that the employee, that the supervisor has acted appropriately the whole time. I mean, if the employee says, well, okay, but Johnny still gives me anxiety, well, at some point, then that if she or he misses enough time, then the time is exhausted. But technically speaking, if you have a condition and it's caused by the supervisor, the employee is allowed to go out. You get 12 weeks of it, but after that, you can manage it, as you would any other absence, unless it's ADA protected. What if we provide the FMLA package, but the employee does not return it? How long should we give them to submit, and how many reminders do we need to do? This is an amazing question. Thank you. I can't tell who's Amy. Great question. Here's what so they get 15 days from their receipt of the FMLA packet to return the healthcare certification form. If they don't do it, I believe best practices is that you send a reminder, you give them 5 days, and then if they don't do it after that, you give them 3 days. Once that 3-day period has expired, then I treat those absences as unprotected. But I think it's the fair way to do it. I think it's also the most conservative way to do it, because you can say we gave them 15 as we were required to, and then we gave them 5 or 7. I don't really care. And then we gave them 3 days after that. That's 2 additional extensions. So that's what I would do. Felicia, you asked to be required to provide FMLA. Do all 50 employees have to be at one work site? Great question. So remember what I said before is there's 2 prongs. First, the employer has to be a covered employer. And for that is you have to have 50 employees anywhere in the world. As long as you have at least 50 employees for 20 or more calendar weeks, you're covered as a covered employer. But remember, the employee still has to be an eligible employee. And here are the prerequisites to becoming an eligible Allison, you asked how much is your handbook? It depends on whether I have to rebuild, if I am renovating, or if I'm knocking down your house and rebuilding. If I only have to renovate a bathroom in your handbook, if you will, it costs less than if I have to knock down the whole house and I'm building from the studs. So I would just have to see your handbook. But what we typically do is give flat fees. And I'll talk about that more in the handbook section. Amy, you're welcome. It's a great question. All right, let's go on to the ADA, because remember, we've talked about FMLA, but it could be ADA as well. In the ADA, the Americans with Disabilities Act, tells us that an employer can do two things, or can't do two things, should and should not. First is you can't take any action against an employee just because he or she has a disability. It also requires the employer to engage in what we call this interactive process with employees so they can assess whether the employee can perform the essential functions of the job subject to a reasonable accommodation. I'll give you guys an example. Yesterday, I got a reasonable accommodation form for a client. They sit in, they said, hey, they're a fast food franchisee, that here's this doctor's note. And the doctor's note said they can't lift over 5 pounds and they can't perform repetitive physical movements. Well, we don't have a job within this particular restaurant that doesn't require lifting more than 5 pounds, or it doesn't require repetitive physical movements. And so in that situation, we can say, hey, look, subject to those restrictions that have been imposed by your doctor, we don't think you're able to perform the essential functions of the job. So we need to know how long you're under those restrictions, because if it's in perpetuity, then you can't be employed here. But if it's only for 2 weeks, then we'll put you on unpaid leave. There's lots of accommodation options out there. Sometimes it can be removing kind of an ancillary job duty. Sometimes it can be a leave of absence. But ADA issues are super, super murky. What you have to make sure that you do is this very last bullet point. You're documenting your communications in writing. Super important for that to occur. If an employee wants an accommodation, it's got to be in writing. And then our response has to be in writing as well. Pregnant Workers Fairness Act, folks, for those who have not dealt with this, it went into effect in June of 2023. It applies to any employers that have more than 15 employees. And it effectively imposes an ADA type reasonable accommodation process for employees that are that have limitations because of pregnancy, childbirth, or related medical conditions. And that means if someone has prenatal issues, that's covered by this. If they have post-birth anxiety or depression issues, it's covered by the Pregnant Workers Fairness Act. So please make sure that if you have a pregnant worker or someone who's given birth, that you're aware of your obligations under this statute. Here are some examples of some accommodations that are identified within the regulations that have been produced. Here's your cheat sheet. This is, I'm telling you all this, but this is what you have to train your managers on, people, the frontline folks. Because I don't want your managers to try and figure out what is the FMLA, what is a disability. Here's what I'll tell you. I'll ask, and if we were standing together, I would make people answer this. But when we have a plumbing problem, who do we call? Call a plumber. When we have an electrical problem, we call an electrician. And when we have an employee problem, we want to get those employee problems in the hands of our folks who know HR. And so this is the way to do that. And the cheat sheet is this. You tell your manager, hey, manager, if you have a medical issue of an employee or the employee's family member, and it's going to impact his or her job, I don't need you deciding anything except to call HR. That's it. And then we get the electrical problem in the hands of the electrician. This is a super helpful cheat sheet and training structure for managers, because you don't want to train them on what the ADA does or doesn't do, or the FMLA or PWFA. It's just, is there a medical issue? Is it impacting their job? Call HR. Part 4, guys, and we're almost done. Paying employees correctly. So we're break this down into non-exempt employees and exempt employees. So for non-exempt employees, what we have to make sure is that our employees know that they are required to clock in, clock out, whether it's an actual clock in, clock out machine, whether it's on your computer, whether it's a timesheet. We have to make sure that we have a timekeeping policy that says you got to record every hour you work. You're never allowed to work off the clock. If you're ever asked to work off the clock, you are instructed to refuse and to immediately report it using that aforementioned employee complaint procedure that we talked about. I never want to see this type of language. Clock in, you can't clock in before your shift. That will get you in a lot of trouble if you have a manipulating or exploitive employee, because the employee says, hey, I wasn't paid for all this time that I came in before my shift and all this time I worked after my shift. And the supervisor says, well, that's not true. Why didn't you clock in? If well, I'll tell you why. And they go to the timekeeping policy, and then they cite to the language that says you can't clock in before your shift. So here's what we say. You're not allowed to start working before your scheduled shift, or you're not allowed to continue working after the end of your scheduled shift. That way we say, whenever you're working, you get paid and you got to report it, but you're not allowed to work 5 minutes before or anytime before your shift or after. If you edit an employee's hourly time, make sure you're documenting why. Obviously, we've got to pay minimum wage on an hourly basis. I know that's not an issue for anybody in the healthcare industry when we're paying lots and lots just to have people come to work. And remember, for anybody who is classified as non-exempt, you got to pay them time and a half for any hours worked over 40 in a work week. And finally, I have some medical practices that do pay bonuses to non-exempt employees. Just have to remember, if you do that, except if you use a particular methodology, you have to reincorporate the bonus into the calculation of their overtime rate if they worked more than 40 hours in a work week during that bonus period. Exempt employees. As you all may know, the current level is still at 684 after the federal court effectively struck down the two increases, one of which had gone into effect, the other that was supposed to go into effect January 1st. So it's currently 684 a week. You have to be extremely careful about when you can deduct from an exempt individual's salary. There are really very limited exceptions. There are exceptions, and I would encourage you to reach out to whoever you use for your employment counsel to find out, if you're going to do this, whether it meets within one of those exceptions. For instance, you can never deduct from an employee's exempt salary for a partial day absence. Can't deduct from their salary, but you can deduct from their PTO. Except one exception, for FMLA leave, you can do that for partial day absences. Why do I bring all these things up? Because it's super complicated, and I want you all to understand it is super complicated. So I want you to reach out to people if you have a question about deductions. Please make sure you're comfortable with your exempt classification. I do have a fair amount of medical practices that when they first hire me, we do a wage and hour audit, a classification audit. And as it turns out, they are classifying way too many people as exempt that should not be exempt. So please be careful with that. And finally, for the exemption, most, I'm talking about for non-medical providers, most of your exemptions are going to be under what we call the white collar exemption. That's the executive exemption, the administrative exemption, or the professional exemption. To establish each of those exemptions, or one of those exemptions, you have to have the predetermined guaranteed salary. It's got to be at least 684. And here's where people screw it up all the time. That individual has to meet the duties test of the exemption that you are throwing them under. So even if you pay them on a salary basis, the receptionist at your medical practice is not exempt. Okay. And so you can pay them, $5,000 a week. They're not exempt 99.9999% of the time because they do not perform exempt duties. Finally, guys, part 5 here. of our 5-part series, Employee Handbooks. Now, remember when I told you all before that the number one thing you can do to reduce your exposure is implement an arbitration agreement? And I 100% believe that. A very close 1A is making sure that you have an updated handbook. If you haven't updated your handbook in 3 years, it is time. Okay. I assure you there's stuff that has happened that you need to update, including adding a Pregnant Workers Fairness Act policy. So my core pillar for handbooks is say what you do and do what you say. All right. And so as an example, if you have a 2-page performance review policy and I ask you, hey, do you normally do this? And you say, nope, we don't normally do this. Then we're going to change it so it reflects what you actually do. Because it needs to say what you do and you need to do what it says. Now, these are the top 9 handbook policies that every medical practice should have in place. There is a tremendous amount to talk about within each one. And for instance, under the standards of conduct, going back to the one question that was asked, the standards of conduct policy should certainly be broad enough that it would encompass bullying behavior that even if it's not unlawful because it doesn't rise to the level of harassment or is not based upon a protected characteristic, would still be highly inappropriate for a professional work environment. For instance, on the PTO policy, for anybody in Georgia, if you have language that pays out your PTO or your vacation or your sick leave for any employee who leaves or is terminated, you are giving money away. It should say, unless applicable state law requires it, we do not pay out unused accrued PTO upon separation of employment. If, however, the employee provides 2 weeks notice and departs on good terms, we reserve the right to decide to pay you. That way, the default is we don't pay you, but if we want to, because you've been with us for 20 years and you're leaving us because you're going to take care of your mother in Arizona, then hey, we can do that. Finally, non-PTO leave policies. I highlighted this. If you have a parental leave policy, understand that you can't give more time off to mom than you can to dad. You can distinguish is what we call a childbirth related leave policy. Those can be complicated, but you can absolutely do them. So if you want to give more time off to mom who gives birth, then we just have to structure it different. We don't call it maternity leave. We would, because unless you're going to give the same amount to mom and dad, but you can give more through a childbirth related leave. I put this as the appendix because ultimately, folks, I don't want you to have to call me when there's a dispute. I want you to call me before the milk is spilled, because that's the best way that milk doesn't get spilled or we limit it. But ultimately, we want to keep disputes within the 4 walls of your medical practice. And I tell folks this all the time. Why do employees seek out an outside voice? This is a chart. The number one reason employees seek out an outside voice is because they don't believe their voice is being heard. So they go get a louder, stronger voice, whether it's a government agency or it's a plaintiff's lawyer. So we want to do everything that we can to ensure that they don't feel like they have to go get an outside voice. And even if we disagree with what they say, we want to make sure that they hear us and we hear them and we understand that they have a concern. And that will go a long way towards avoiding them seeking an outside voice or taking a dispute outside the 4 walls of your medical practice. With that, we are done. I'm going to answer a couple of the other questions. I want to be respectful of your time. It was supposed to end at 1 o'clock, so we're 3 minutes over. But I do see that Amy has a question, Kim has a question, Wendy has a question, Amy has another question. So for those that want to stay on, I'm happy to answer them. Amy's question is, can you have more than one person qualify for FMLA on the same individual? Yes, you can qualify for, you can have 2 quote unquote serious health conditions. You could even have it where you have a broken arm and you have anxiety. As long as you would get certification form for each condition. then you can qualify. But you still only get 12 weeks of leave. So you could have 10 different conditions, but you still only get 12 weeks of leave within, hopefully you're using a rolling calendar basis. Amy, hopefully that answered your question. Again, you're welcome to call me afterwards if you want to talk in more detail. Kim, you asked, can we require actual 40 work hours for exempt staff? 100% you can. Absolutely. You can require 45 or 50 as long as they're properly classified as exempt. You don't have to pay overtime at all. Wendy, you asked, can you go into more detail about the bonus hourly employee that you mentioned? Here's what I would say, Wendy, it's probably easier for you to call me. Here's my number. But the long and short of it is if you pay a bonus to an employee, unless you pay a percentage of earnings bonus to a non-exempt employee, and they worked more than 40 hours during what you consider your bonus qualification period, you have to reincorporate that money into calculating how much overtime they got, because your regular rate goes up because more money is added to the pot. So what you're multiplying time and a half by is higher. So if I'm dividing, I'm making it up, 600 or 500 by 10, and you gave me or 500 by 50 hours, and you gave me a $500 bonus, well, $1,000 is now divided. So that's going to be a bigger number that I multiply time and a half by. If that didn't answer your question, Wendy, please feel free to call me. Amy, you asked, we have an exempt, we have an exempt employee that abuses taking time for partial days. They are on PTO, they take a call or had to log on to help someone, especially an RT person, then they don't want to use their PTO. Ooh, this is such a great question. Guys, just remember this. PTO is not a guarantee that someone gets a day off. The only thing that PTO is, it is a bucket of time that, if approved, they can pull hours out of to pay themselves. But let me give you an example. Let's say you have an employee that has 52, I'm making it up, but gets 52 days of PTO. It's front loaded. They get it on January 1st, and they come to you on January 2nd and they say, hey, Darcy, or hey, Connie, or hey, Matt, just want to let you know that I plan on taking off every Friday this entire year. I have 52 days of PTO, and I'm going to take off every Friday so I can have a 3-day weekend. Well, of course, you don't have to approve that. So just remember, just because someone has PTO doesn't mean you approve PTO or have to approve PTO. And if someone is abusing time, so they are coming in and they're working for 5 minutes and they're an exempt employee, so you got to pay them for that whole time, although you can deduct it from the PTO bank, then that is a counseling issue. Someone is coming in and they're working 10 minutes and they're leaving, and that's happening on a regular basis, then that's a performance management problem, and you need to treat it as such by using the counsel doc. I hope that answered your question, Amy, but please reach out if you want to discuss. That's a great question. Ms. Patel, you asked, and then if a current employee refuses to sign the arbitration agreement, what do we do? Again, we addressed this, but you have to tell them. First, I'd find out what their concern is. Most of the time you can address it. 2, if they don't sign it, I think you have to say this is a term and condition of continued employment. And if you don't sign it, we cannot continue to employ you. You just have to, it's a non-negotiable, because the person who doesn't sign it, it's the person who creates the issue. Let's see, can an employee request for a different supervisor because they don't agree with their personality? They can, but that doesn't mean you have to grant it. But so legally, you don't have to grant it. But part of what our job is as an employer is we're trying to put people in the most successful positions so they can be productive, they can be happy, they can be high integrity, they can be loyal employees. So if that means that we need to assess that option, you can, but I'm not just going to say yes just because you don't like your supervisor. That's just, it's part of life. You may not like everybody that you have to report to or work with. Janet, hey, by the way, Janet, good to see you. Terminating for bullying versus poor performance, same protocol with documentation, 100%. If you're terminating someone because of because to me, bullying is I mean, I guess it's not meeting expectations. Whether it's performance or bullying, same thing. There needs to be counsel docs. I don't see any other questions, and so I will. Beth, I just saw your question. Just reach out to me, and I'm happy to talk about that technology resources policy. If you guys want to unmute yourself versus chatting, you're welcome to ask questions. I will stay as long as you guys want me to stay. As you can tell, I feel really passionate about this subject because the most work I can do to prevent an issue is before it becomes an issue. And I love to do that, to put ourselves in the best position to defend a claim and frankly, keep the money where it belongs, which is with you and not me. With that, I don't have any other questions. John, I don't know if you're still on, or Bartley.
Bartley's taking over.
Appreciate it. Okay.
Yeah,
Hey,
Brad, thank you so much for this presentation. I'm already getting text messages and comments about how well it went and what a great job you did. So thank you so much. If anybody wants to hang on for a little bit, I think Brad's going to hang on here for a minute, but that concludes our presentation. We appreciate everyone joining.
Thanks, folks. I'll just hang on for 5 minutes and just in case someone wants to ask a question. If not, then I will sign off as well. But here's my contact information, and please reach out if you have any questions. Thanks so much. Go forth and conquer. Have a great day.
Thanks, Brad. Great information.
Brad, I do have one
Yes,
great information. Thank you.
of course. I heard someone say they have a question.
It was me, Amy.
Hey, Amy.
You did answer what I would have wanted to know on the FMLA, except that I was asking, can more than one person take FMLA to care for the same person? So I know that an individual can take it like you answered, but my question is, can more than one individual care for the same? Mine's an adult parent who has dementia, and the brother lives in the state where the dad is and has been the primary caregiver. And they're now looking to move him to a new facility. And so my employee, who I'm in kind of counseling already in the early stages, so I don't feel like it is I'm ready to do anything major about it yet, but she doesn't have a lot of time. We've had the flu and COVID and everything else like everybody else, so they don't have a lot of time. She wants to take time to make phone calls and look for somewhere for him to be. I do think they're going to end up moving him here, and she'll become more the primary caregiver, if you will. But does she qualify as a primary caregiver if she's not in that same state and does not serve that capacity right now?
When she cares for that, she doesn't have to be a primary caregiver. Okay.
Okay.
You have to be giving care for someone who is incapable of self-care.
Okay.
So there's no requirement to be a primary caregiver.
Okay.
So the answer would be yes. So even if older brother is helping mom or dad, but older brother goes off to Europe for a business trip for 2 weeks, and you're like, okay, well, I got to go help mom and dad because mom and dad's got a serious health condition, is incapable of self-care, and that qualifies.
But looking around for facilities and where they might want to put him, does that qualify? I mean, I don't want to split hairs because I want them. And she technically is not at her 12 months yet. And I don't know whether to allow her to go ahead and start her time or use up all her time now. And then when April 1st rolls around, then she's got 12 weeks. But I really need to wait till that 12 weeks, till the year is up.
Yeah.
I feel like I'm setting precedent otherwise.
Yeah. Let me say this. I can look. The regulations don't talk about, like looking for a facility, but I'm just going to tell you, practically speaking, I am not touching that. And if you feel like it's getting abused, that's a different deal, right?
Right.
And then we need to manage that situation tighter. But my view is, as an employer, I'm trying to defer and give the benefit of the doubt to employees until they give me a reason not to give them the benefit of the doubt. So that's the way I would approach it. You had great questions, Amy.
Thank you. I appreciate it. Sometimes too many, but it was a new perspective for a lot of things. Thank you. I really enjoyed it. Thank you.
Yeah. I'm giving you, as a professor, I'm giving you an A+.
Thank you. Thank you. I appreciate that.
I think Ms. Taylor, do you have a question?
Yes. Hi. Can you hear me okay?
Yeah, sure can.
Okay. So, I'm thinking about like work from home employees, um, and thinking about how to best implement is who qualifies as working from home versus not, and just allowing those that can work from home to work from home without it being discriminatory of employees that are unable to work from home. Do you recommend having some sort of, or including that within the employee handbook, as far, as far as like if you qualify for, if you fall under these qualifications, you are allowed to work from home, so that can
Sure.
prevent any sort of
Yeah.
discriminatory.
Well, here's what I'd say. I'm fine with having a generic telecommute policy in the handbook, but if you're, I mean, I like the idea of having a telecommute agreement
Mhm.
that people sign, and it says things such as you agree that telecommuting or remote working is not an alternative to childcare, and we expect you to be available at the same level that you would be available in the office, and to have a professional workspace and everything like that. So I don't have any issue with having a telecommute policy, but I would put in there that a telecommute individual is going to be required to sign a telecommute agreement or an acknowledgement. It doesn't have to be an agreement. I mean, when I say an agreement, it would just be an acknowledgement, a separate acknowledgement of the company's telecommute expectations.
Okay. Okay, thank you.
Absolutely. Thank you for the question. Great question. Ms. Covington, you asked if you have an ex-employee who still wants to visit the business, how is that handled? Well, I guess you have to first decide if you're bothered by it or if you're okay with it. If you're bothered by it, you can ask that employee not to visit the business. And if the employee continues to visit the business after you've said, hey, I don't want you to, then you can trespass them. I've written lots of trespass notices over the years. It's a letter that says you're not allowed to come on to these premises anymore. But obviously you hate to get to that point. So I think, again, you have to first decide, is it causing a distraction? If it is, if it's problematic or it could lead to a problematic situation, then I would just have a conversation with the person and try and resolve it that way first. But technically speaking, at the very end of the process, if they're not listening, we trespass them. And in terms of the, some people ask, can we get a copy of the PowerPoint presentation? 100%. And Katie and Tammy with Sterling Seacrest have a copy of it. So I will leave it to them to share with whoever wants a copy, but I'm happy for you guys to get it. Please use the forms that I have in there. That's why I included them. What other questions, guys? This is all free, but please ask away. Okay. Well, I think then, unless I hear anything in the next 10 seconds, I think we are done with the Q&A. Thanks so much again. I see lots of familiar names, or I saw lots of familiar names and still do on this presentation and on this webinar. So thank you. I know it was a little bit longer of one, but we touched on a lot of topics, and hopefully you gleaned some important insights. If anybody ever has any questions, please feel free to reach out to me. You can call me, you can email me. I love working with medical practices on an advice and counsel basis, and would obviously love to work with you guys. So thanks, everybody. Have a great day.
Thank you, Brad.